Hello everyone, my name is Renato Costa, this is Aussie Law, and today we'll see how the High Court of Australia shifted from a singular to a multiple characterization of federal laws by analysing a case called Actors and Announcers Equity in Fontana Films from 1982. In our previous video, we saw how the High Court of Australia changed its approach to the characterization of federal laws from a substantive to a narrow approach. There, I commented that when adopting a substantive characterization, the High Court of Australia tends to find one true nature and character of the law. So a Commonwealth legislation will have a singular character. It could only refer to one unique head of power in the Constitution. Even though the law may have different characters, the role of the court was to identify the dominant, the essential character of the Commonwealth law. Well, as we have seen, the tides change. The High Court, since the Engineers case, adopted a narrow characterization, and with it, it became unnecessary to identify the one true nature and character of a federal law. All that was necessary was to check whether a law possessed some characteristic, one characteristic that enabled it to be qualified and classified under one of the Commonwealth's heads of power. The High Court then has now been adopting the view that it is not necessary to characterize the law as having only one dominant or unique subject matter. The law, as was expressed in Actors and Announcers Equity in Fontana films, may possess a number of quite disparate characters. Indeed, the High Court of Australia now adopts the dual or multiple characterization of federal laws. The court admits that a federal law may have more than one single subject matter for constitutional purposes. And if that's the case, if at least one of the subject matters belongs to the enumerated list of Commonwealth powers, then that law can be valid for falling within that head of power, even if, to a certain extent, the law also deals with matters that are usually residual to the states. As Justice Mason said in Murphy Laws Incorporated in the Commonwealth from 1976, it is no objection to the validity of a law otherwise within power that it touches or affects a topic on which the Commonwealth has no power to legislate. So let's look at the case called Actors and Announcers Equity in Fontana films from 1982, because that is where we find the first clear statement about the approach to the characterization that now shapes the High Court's decisions. Fontana Films was a trading corporation within the meaning of Section 5120. They rejected to enter into an agreement with the Union of Actors and Artists. The rejection was based on a clause of the agreement that forced the trading corporation to give preference to hiring unionized members when producing a particular film. Because of that, and as Fontana argued, the union exerted pressure on theatrical agencies to boycott the corporation and stop supplying actors and artists to Fontana. Fontana then asked the federal court for an injunction based on Section 45D of the Trade Practice Act of 1974, which prevented secondary boycotts. Now, secondary boycotts are the conducts that hinder or prevent the supply of goods or services by some other person to a trading corporation. So Fontana was arguing that the union breached the law by promoting the boycott of the theatrical agencies to the detriment of their corporation's businesses. So the issue that ultimately went to the High Court of Australia was whether the law was a law with respect to corporations according to Section 5120. The High Court of Australia decided that the law was valid under the corporation's power of Section 5120 because the Commonwealth could regulate the conduct of others if they affected the business of the trading corporation. Do you realize what happened? The law did not regulate the conduct of corporations. It was not a law whose dominant character concerned constitutional corporations at all. Nonetheless, it regulated the conduct of people that could potentially affect corporations. And since corporations are among the heads of power with respect to which the Commonwealth Parliament can legislate about, the court found the law to be valid and thus fairly within the scope of the corporation's power. Even though the constitutional corporations were not within the main scope of the federal law, the law nonetheless regulated them. Ultimately then, the High Court accepted that multiple characterization is permissible as long as one of the law's many characters falls within the head of power. The purpose or the motivation behind a Commonwealth law is generally now irrelevant. Chief Justice Gibbs was of the opinion that the law in the present case does not regulate or govern the activities of trading corporations. It regulates the conduct of others. But the conduct to which the law is directed is conduct designed to cause and likely to cause substantial loss or damage to the business of a trading corporation formed within the limits of the Commonwealth. I can see no reason in principle why such a law should necessarily fall outside the scope of Section 5120. A law may be one with respect to a trading corporation, although it casts obligations upon a person other than a trading corporation. With that, the High Court decided that the law was valid. In this case, Justice Stephen expressed the position of the court concerning the possibility of multiple characterization. Look at what His Honour said. This court's process of characterization is free to recognize that laws may in truth possess a number of characters. To recognize that a law may possess a number of quite disparate characters is, then, to accept reality. Few laws will involve only one element: to accept as constitutionally permissible the fact that a law may bear several characters, each as valid as the other because each is reasonably capable of fairly describing the law as a whole, disposes of the need to rely upon what may prove to be quite subjective reasons for selecting one particular description only. His Honour then provides the clearest path to the new approach of characterization adopted by the High Court of Australia. Once it is recognized that a law may possess several distinct characters, it follows that the fact that only some elements in the description of a law fall within one or more of the grants of power in Section 51 or elsewhere in the Constitution will be in no way fatal to its validity, so long as the remaining elements which do not fall within any such grant of power are not of such significance that the law cannot fairly be described as one with respect to one or more of such grants of power, then however else it may also be described, the law will be valid. If a law enacted by the federal legislature can be fairly described both as a law with respect to a grant of power to it and as a law with respect to a matter or matters left to the states, that will suffice to support its validity as the law of the Commonwealth. For His Honour, the process of characterization does not require a search for one sole or predominant character, where the law in question can be seen to possess several characters. So today, this is how the High Court approaches the characterization of laws. A single law can possess more than one character in the sense that it can properly be characterized as a law with respect to more than one subject matter. It suffices for constitutional validity if any one or more of those characters is within a head of Commonwealth legislative power. In determining validity, it is not necessary to single out the paramount character. It is enough that the law fairly answers the description of a law with respect to one given subject matter appearing in Section 51, regardless of whether it is at the same time more obviously or equally a law with respect to some other subject matter. A case that confirmed this view now dominant in the High Court of Australia, the multiple characterization, was the work choices case. The Work Choices Act was enacted under the Corporations Power of Section 5120 to avoid any controversy about the limits of Section 5135, the Industrial Relations Power. Since the court adopted a wide view of the corporation power in that case, the law was considered to be constitutional. Because even if it were to be found unconstitutional under Section 5135, it didn't quite matter. The dual or multiple characterization concedes the constitutionality of a Commonwealth law as long as that law falls within the scope of at least one head of power. Hey, you know what? We have a whole video explaining the Work Choices case. So click the video that is appearing in your screen and check it out for yourself. If you already subscribed to our channel, I'll be seeing you again soon. Until then, ciao.